And leave to mention, my lord, the two matters which were fixed at our instance on the 15th to be returnable, my lords. Very interesting points of law. But I'm in some personal difficulty. Perhaps I'll not be in Calcutta. I've informed the other side. I've informed Mr. Chaudhary, and he has indicated that he has given consent. The only difficulty Mr. Chaudhary also requested, because he will not be here on 18th and 19th. So if that next week, if the matter is not kept, and thereafter on Monday, we can come and assist your lordship. I'm handing over the slips, my lord. My learned friend is here.
Gammon. Yes, my lord, I don't have any objection.
Gammon and in Pural, there are two matters, my lord.
Right. But barring 18th and 19th.
18th and 19th, Mr. Chaudhary told me. He's not here, he's in Odisha.
So then it won't happen this side of the year.
We'll do it on 22nd. My lord, it's the next Monday. Lordships, if your lordship is pleased to keep it next Monday, we're ready in
Is here.
I gave a call to Mr. Chaudhary and I said,
told me that I want to mention. I said I'll never stand in the way. But question is, when will you? If you'll
for next in January.
We'll come back.
That, if you
let the matter come on the 15th.
Yes.
You have mentioned. We'll accommodate you on the 15th.
Very accommodate.
But this side of the year, it's difficult.
I understand that, my lord. I understand that.
Because the last week, bit up.
We'll come back, my lord. We'll come back on
final, hearing matter.
The difficulty
is very difficult.
Last week is not for hearing matter.
That's right. Last week is not for.
But I'm taking my chance and mentioning this because I'm told at 11 o'clock they'll mention the matter in Odisha, and the outcome will depend thereon. I said I'm not going to take a chance, Odisha, because of 15th I'll not be here in Calcutta. So today at 11 I'll actually come to know whether I'm there on Monday or not. But I didn't take a chance. I had to mention if I'm not there, then it will be.
If you're again,
if you're there, we'll do
if
the
you're
matter.
there, if I'm there, I'll do the matter. If I'm there, I'll definitely do the matter.
We'll accommodate you, but if you're there, then
my lord, definitely. I'm very deeply obliged.
Lord, you may be permitted to mention appellate side for inclusion, my lord. Recording application, my lord. Appellate side, my lord.
Appellate side, what is it?
For inclusion, my lord.
What inclusion?
For recalling order, my lord. I served the other side. Notice I have served for other side, my lord. My lordship order, my lord. That is 11 July 2025.
Mention it on Monday.
Monday.
My lord, may I have
the details?
I have
mentioned.
I served the notice other side also.
My lord, may I
mention it on Monday? I'll just take the details. Details de lena jar just.
Again, I mentioned Monday.
Yes, Monday you mentioned.
My lord, may I have my lord's leave to mention, my lord?
Just write down the details and give it back to him. Let him mention.
My lord, may I have my lord's leave to mention a section 34 application? Yesterday, my lord, an execution case was heard. My lord, it's a 2018 section 34 application. My lord has adjourned the section 36 execution till Thursday. My lord, Mr. Jishnu Chaudhary, on the short point, my lord, yes. My lord, I'm mentioning that for inclusion.
Yes, my lord, just on a short point, whether there can be retrospective enhancement.
Yes.
My lord, may I have...
We'll keep it. Did we indicate a date?
Monday or Tuesday, my lord, or Wednesday, my lord, whenever.
Matters. One is that EC.
EC is coming up on
Thursday.
We'll have it all matters on the same day.
Thursday, my lord, I wasn't there. I indicated yesterday. Your lordship said you mentioned tomorrow. So if this could come up by Wednesday, my lord, any day.
Have you given all the other numbers also?
We'll just put in.
Let's give all the
any day convenient, no, I won't take more than 5-10 minutes.
Wednesday.
Grateful.
My lord.
Which should we see come 510 of 22?
You have given notice to the other side.
Yes. This is the notice, email.
My lord, may I have your lordship's kind leave to mention that Jute Corporation section 34 matter your lordship has heard, my lord, and reserved for orders. My lord, may I hand over the written notes of argument?
I was waiting for this.
My lord, just become bulky because we've taken the liberty to annex those judgments again, my lord.
Helpful. Thank you.
May I have a lordship please mention this matter, my lord? There is a small defect in the file.
Sorry.
There is a small defect in the file. The certified copy contains the short signature of the arbitrator, not the full signature. I'm praying for a leave.
You You need a full signature of the arbitrator.
No, this is a short signature. We need a full signature to file the application. The initial signature is there.
Yes.
We need a full signature. We have already shot for the rectified copy. They will provide us the rectified copy. Then we will file it.
So what do you want?
I'm praying for leave to file the.
All right.
Grateful Lordship.
Call out the list. Yes. This court is thus left with no alternative but to exercise its jurisdiction under Section 34 of the Arbitration and Conciliation Act 1996. The present arbitration petition is allowed. The impugned arbitral award dated 28/1/2020 passed by the learned sole arbitrator in the arbitral proceeding so and so is hereby set aside in its entirety. The parties shall be at liberty to have their disputes adjudicated afresh by initiating a new reference in accordance with law. If they so choose, all the pending application stands disposed.
I'm very deeply obliged, my lord. Grateful.
Grateful, my lord.
No, what are happening? There's no sign to it.
Date क्या? 12 है. Yes. Call out the list.
Two.
This matter has been settled between the parties. I'm praying for withdrawal.
Learned counsel for the petitioner states that the matter has been amicably settled between the parties.
Interim order should be vacated. Interim order should be vacated. Lordship.
And between the parties, she wishes to withdraw the present petition. The same is dismissed as withdrawn. All interim orders, if any, stands vacated.
Grateful Lordship.
Do you have any instruction? You want to keep the instruction on record, madam?
Yes, Lordship.
Do you have any instruction?
Instruction to record.
Then I'll record a line.
Is given.
Instruction given by the client is kept on record. Instruction to withdraw the present petition given by the client is kept on record. इसको डाल दो. Next.
Lordship, the matter has been settled between the parties. I wish to withdraw. There's a warrant of arrest needs to be discharged.
Instruction kept on record. Interim order stands vacated. Withdraw. Dismiss. Interim order is vacated.
That should be the same. I'm praying for a withdrawal. We have the instruction. Grateful Lord.
Kept on. Same. Yes.
My lord, I am appearing on behalf of the petitioner, my lord. My lord, this present application has been filed seeking restoration of the main application being APCOM 720 of
Please serve with a
2024.
copy of the application, my lord.
My lord, it's just a simple restoration application.
Restitution.
34 can be heard, my lord, if it
My
can
lord,
be.
before
Because this 34 is, my lord, challenging an interim award, my lord. That was passed on an application filed by my client for summary judgment. Now, in that arbitration, the arbitration proceedings have been concluded, my lord, and the final award is already there, which they have challenged by way of another application under section 34.
my lord, that does not deem infructuous of this present interim award challenge.
Because after evidence, my lord, the arbitrator has come to the same finding.
My lord, that interim award challenge is different. My lord, the application for the challenging the final award
Let
is
it come
different.
in due course. Take down. GA, what is GA number?
GA1, my lord.
G1, my
Let them
GA1.
serve a copy at least, my lord.
The petitioner has preferred the present petition seeking restoration of the seeking recall of the order dated 10th November 2025, whereby the petition was dismissed for default. Full stop. He has filed the present restoration application. Full stop. I am sure you don't have any objection to restoration.
I don't even know what the
There's no ground. What ground? Restoration is restoration. For the reasons stated in the application and the concession granted by the learned counsel for the respondent, that he has no, and the concession granted by the learned counsel for the respondent, that he has no objection to the present application. The present application is allowed. Matter is restored to its original position. It's restored to its original position. Application disposed of.
Very deeply
Let it
obliged.
come in the whatever list it is. Then you mention it.
My lord, be pleased to fix any date for hearing, my lord, on the January, in case, my
Let
lord.
it come in the wherever the list is. Then you'll see that.
Much obliged, your lordship.
Give a copy of the application.
My lord, I beg to appear on behalf of the appellant, my lord. I have served, my lord.
But I am going for the respondent number 1, 2, and 3.
My lord, arbitration proceeding, my lord, commenced, my lord, on 14/9/2022. My lord.
When was the arbitrator appointed?
My lord, the first sitting was on 14/9/2022.
First?
First sitting was on, my lord, 14/9/2022. Despite lapse of, my lord, this time, my lord, though there was a mutual extension for another 6 months, 29/3, my lord, and despite that, my lord, the proceeding has been stalled, my lord. I am the claimant therein and, my lord, petitioner herein, my lord.
What are you seeking? Extension, right?
My lord, extension and, my lord, if your lordship, my lord, appoints, my lord, another arbitrator, my lord, because they are not willing to, my lord, proceed with the arbitration, my lord.
Why?
I don't know, my lord, and I am suffering, my lord.
You're not participating.
Yes, my lord, we are participating. My lord, one thing, my lord, they did not disclose. My lord, almost, my lord, the 1 year, my lord, the elapsed. My lord, on their application, my lord, the learned advocate commissioner, my lord, appointed, and my lord, after 1 year, my lord, the report was submitted. My lord, that was the one of the reasons for delay. My lord, regarding, my lord, the extension and, my lord, the change of arbitrator, we have nothing. My lord, we are participating in that proceeding. But the allegation is most against the learned arbitrator.
If your lordship direct peremptorily to conclude a specific time frame, then it can be concluded. And if your lordship thinks fit to appoint some another set, we will start right from the proceeding where it is right now, then and in both the cases, I believe my learned friend will not come in the way.
What is the delay? What is the delay? What are the grounds you're seeking?
Kindly takes up page 10, ground number 9. The extended period of 6 months lapsed on 16/6/2024. It was extended for a period of 6 months with the mutual consent. Then that 6 months has already lapsed.
(29A) is not for termination of the mandate.
No, that is for extension
That's
of
for
time.
extension of time.
Extension of time.
You're asking for termination of the mandate. Termination of the mandate is either you challenge it under 16 or some ground has to go before the arbitrator. Sir, you're seeking a termination of the mandate in 29.
29A consequential action extension and expedite the proceeding. That is Priya C.
The arbitration is not concluded within 12 months. It's automatically terminated. So where's the question of this application? Either you're seeking extension, then it's a different thing.
That extension will be granted peremptorily, if you lordship.
Sure, that is not what you're asking for. You're asking for termination of the mandate.
That is foremost, and at the same point of time, if that
That's what I'm saying. Then how is this application maintainable? Application is defective. Defective application, sir. Take down. Can't file anything. This is your application. The present application has been filed by the petitioner under Section 29A of the Arbitration and Conciliation Act 1996, seeking termination of the mandate of the arbitral tribunal and reconstitution/substitution of the tribunal on the ground that the tribunal has substantially delayed the arbitral proceedings. The case of the petitioner is that pursuant to the invocation of the arbitration clause contained in the development agreement dated 29/10/2013, comma, the petitioner, comma, wide letter dated 21/1/2022, appointed Sri Anirudh Bagchi as the nominee arbitrator. Full stop. The respondent initially nominated Sri Priya Brata Thakur as its nominee arbitrator, comma, who subsequently resigned. Full stop. In his place, the respondent appointed Saurabh Sen, comma, advocate Sen, S-E-N, Saurabh Sen, comma, advocate, comma, as their nominee arbitrator. Full stop. After several sittings, Shri Pratanu Dev Mukherjee came to be appointed as the presiding arbitrator. Wide minutes of the meeting dated 7/6/2023. Learned counsel for the petitioner states that the arbitral tribunal has failed to conclude the proceedings within the statutory prescribed period of 12 months, comma, or even within the further extended period of 6 months. Full stop. Consequently, comma, the mandate of the arbitral tribunal stood terminated on 16/6, right? 16/6/2024. Is it 2024 or 2025? You are right. 2024. 2024 under section 29A(4). 29A capital bracket 4. Full stop. It is submitted that the matter continues to remain at the evidence stage, comma, and that the delay is attributable to the arbitral tribunal. Full stop. On this basis, comma, the petitioner prays for substitution of the entire tribunal. Full stop. At the outset, comma, this court notes that by operation of section 29A(4) of the Arbitration and Conciliation Act 1996, comma, the mandate of the arbitral tribunal stood automatically terminated on 16/6/2024. Full stop. As on date, comma, there is no subsisting arbitral tribunal whose mandate can be terminated, comma, extended, comma, or continued, comma, and consequently no occasion arises for exercise of powers under section 29A(4) or 29A(6). Full stop. This court further notes that the present application is defective. Full stop. The petitioner has not sought any extension of the mandate, comma, either before its expiry or even in the present application. Full stop. Under section 29A, comma, substitution of an arbitrator under subsection 6 is permissible only while considering an extension of the mandate which is not sought in the present application. Full stop. Substitution cannot be granted as an isolated relief once the mandate has already expired. Full stop. In the absence of a subsisting mandate and in the absence of a prayer for extension of the mandate of the arbitral tribunal under section 29A, comma, this court lacks jurisdiction to entertain the reliefs sought by the petitioner. Full stop. The present petition is accordingly. Shall I dismiss or do you want to withdraw it? Dismissed as infructuous.
With the liberty to file appropriate application.
Not maintainable. Full stop.
With the liberty to file appropriate application. Right?
Then you should have withdrawn it. I'm telling you it is not maintainable. Still, how can you file a 29A for substitution, sir. What is the mandate of 29A? It's an
My
extension.
lord, I'm withdrawing it to come up with a fresh application, my lord, for
Do whatever you want. Infructuous.
with the appropriate sections at my lord prayer. Withdrawal, my lord.
Not maintainable. Dismissed as infructuous and not maintainable.
And my lord, leave be granted, my lord, to come up with.
Petitioner is at liberty to file appropriate proceedings in accordance.
Much obliged, my lord. Much obliged. Much obliged. With leave, my lord.
Now, I appear for the petitioner, my lord. This is my app.
I appear on behalf of the respondent.
Yes.
This is my post award section 9 application. My lord, the award was passed on 27th of October 2025. My lord, my apprehension that my lord, the award will become infructuous, my lord, so long, my lord, when the time for execution comes, my lord, they did not appear in section 11 application. Thereafter, before the arbitrator, they had avoided notice, my lord, paper publication was made, and thereafter also, my lord, they have
Post award section 9.
Section 9, my lord. I'm only seeking for an order, my lord. There is one bank account, and that is at page. Not you will find it at paragraph 21 and 22. There is a property in which he has a interest. I have, my lord, annexed relevant documents from the government of West Bengal's, my lord, website showing his interest in the property. I am only seeking for an order for security. The award is at page 21. Sorry, my lord, page 19 onwards.
Yes.
My lord, in this matter, my lord.
Have you challenged the award?
No, my lord. We are yet to challenge the award. We have time till 26th of February, I presume.
Yes, tell me, what is your any objection? We'll secure it.
The objections, I have no such objection, but my only contention is, my lord, that post section 9, my lord, the parameters are quite high,
Yes.
which they have to prove. Firstly. Second, my lord, I will be very candid before the court, since my chamber senior, Mr. Lakhmani, Rachit Lakhmani, always says that I'm an officer of the court first before representing a client. So, my lord, in this bank account, there is approximately around 40-50,000 he has. My client is a thumb impressioner. He had a shop which he had to sell because he had to pay off a bank loan, and the property which has been mentioned is a co-owned property by the petitioner along with his siblings, out of which around 5-6 rooms have been tenanted, from which he is earning the respondent is getting around 12,000. So 6 tenants, 2,000 each, so 12,000. So today I am willing to give my client is willing to give an undertaking that he will not be creating any third party rights in the particular building where he's staying, because if he sells off that building or that property, he will have nowhere, he will be homeless.
Noted. Fortifies
his
my
apprehension
that they cannot pay the debt. They will not
His
be able to
apprehension
pay.
is correct.
because
That's the reason
will
why he
have
has filed it.
he can exercise those same rights in the execution court as well.
Well, that's a separate matter. We have to wait till February. That's why.
That they have to wait till the 34th.
And my lord, we shall be filing a section 34 with regards to only challenging the interest which has been granted by the learned arbitrator. That's 18%. We feel it's.
Sir, in that case, we'll let them at least secure the
Your
principal
argument
amount at
itself
least.
gives him a reason to be secured.
I agree, my lord, but these are the facts. I can only give an undertaking, my lord, that every month out of the 12,000, around 8,000 or anything which my lord decide, he can pay it off to the petitioner every month.
Take down the petitioner has preferred. the present petition under Section 9 of the Arbitration and Conciliation Act, seeking interim measures for securing the awarded amount of rupees 31,75,440. That's the amount?
Yes.
31,75,440
Yes, madam.
as granted by the arbitral tribunal wide its award dated 27th October 2025, comma, either by attachment of the respondent's bank account or as detailed in paragraph
Let paragraph 21.
as detailed in paragraph 21 of the petition, or comma, in the alternative, comma, by attachment of Schedule B property.
The schedule is at page 17.
Schedule B property at page 70 of the petition. Full stop. Learned counsel for the petitioner submits that disputes arose between the parties on account of the respondent's failure to pay the value of the TMT bars sold, supplied, and delivered by the petitioner. Full stop. Pursuant to the order of this court dated 7/4/2025, an arbitral tribunal was constituted. Full stop. The respondent failed to enter appearance in the arbitral proceedings, and the tribunal proceeded ex parte, passed the award dated 27/10/2025, allowing the petitioner's claim along with an interest of 18% per annum. Full stop. The petitioner submits that the total awarded amount at present stands at rupees 31,75,440 and seeks interim protection for the same. Full stop. Learned counsel for the respondent states that he has not challenged the award till date. Full stop. He further states that he is in the process of challenging the award. Full stop. He states that his client is a person with low financial income, and that the account which is mentioned does not have the adequate amount of money to secure the petitioner. Full stop. He further states that the property mentioned at Schedule B is a jointly owned property, and that the respondent is drawing a paltry amount of rupees 12,000 as monthly rental from the said property. He further undertakes that shall I just take his undertaking, and what's the point of?
I was only hoping for if your lordship kindly injuncts them to their interest, to the extent of their interest.
He's making that submission that he will not sell.
Undertaking he withdraws if he breaches that, the only option for me is for a contempt or something. Otherwise, if there is an injunction, at least I am saved. That is why
the respondent.
Well, the value of the property is much more than this 31 lakhs. Therefore, if only a particular, perhaps 2 or 3 rooms of the particular property can be injuncted.
Right now, we can't say that. Though he states that he is ready to give an undertaking that he will not be creating any third-party rights by alienating, encumbering the property. Full stop. This court notes that the award dated 27/10/2025 has neither been challenged nor stayed by the nor there is any stay against the said award. Full stop. It is further noted that under Section 36 of the Arbitration and Conciliation Act 1996, an arbitral award becomes enforceable as a decree upon the expiry of the statutory period for filing objections, unless stayed by a competent court. Full stop. As this is post-award pre-enforcement stage, the petitioner, being the award holder, is entitled to seek protective measures to ensure that the award is not made illusionary. Full stop. The power of the court under Section 9 of the Arbitration and Conciliation Act extends to granting interim measures even after passing of the award, but prior to enforcement, when such measures are necessary to secure the awarded amount or to prevent frustration of the award. Full stop. The Supreme Court has recognized the post-award relief under Section 9 of the Arbitration and Conciliation Act as maintainable, where the award holder demonstrates a reasonable apprehension that the award will be defeated or made illusionary. Full stop. In the present case, there is prima facie material on record indicating that unless secured, the awarded amount may not be recoverable at the stage of execution. Full stop. The petitioner has established a strong prima facie case. Full stop. The balance of convenience is in favor of securing the award, and irreparable prejudice would be caused if the respondent is permitted to deal with its asset in a manner that will frustrate the execution of the award. Full stop. In view of the above, this court is satisfied that interim protection under Section 9 is warranted. Full stop. Accordingly, the respondent is restrained from selling, alienating, or creating any third-party right of his property mentioned in Schedule B at page 18 of the petition.
17. Schedule B, page 17. It's also there in paragraph 22.
Page 17. My page 17 is affidavit. Check it out.
The Lordship will kindly take then paragraph 22, my lord. It is also
Para 22. Schedule B mentioned at para 22 of the petition. Full stop. With the I think bank account is not necessary. There is no money.
Will not serve any purpose, my lord.
His business will get affected by that.
He says it is valued more than the award.
Period, the petitioner is at liberty to initiate steps for enforcement of the award dated 27/10/2025 in accordance with law. With the aforesaid direction, the present petition stands disposed of.
Deeply understood.
I appear for the respondent. Lord, at the risk of being severely reprimanded, my lord, would it be my lord's pleasure to record my preliminary objection? This application is not maintainable, my lord. May I just indicate? I'll just put my learned senior friend, my lord, on notice. My lord, this is an application under Section 34 that's been taken out.
Yes.
Possibly, my lord, this does not lie because the order challenged is under Section 16, 2 and 3. So there would be an appeal that would have to be preferred under Section 37. So, my lord, that's my preliminary point. My lord, I'm taking No. Apart from that, on merits, my lord will hear me. But may I just indicate that point? The arbitrator holds. Yes, my lord. We're relying upon
My
two
lord, Indian
judgments.
farmers case has decided this.
আপনি airdrop করে দিন আমরা দেখিয়ে দেব
এই
iPad
কপি নেই
আমি আইপ্যাড দিয়ে দেখিয়ে দেবো আপনি airdrop করে দেন আমাকে আমি আমার আইপ্যাডটা দিই
It's an interim award.
My lord, it's the interim order. The arbitrator also terms it as an order. I can indicate, my lord, volume 11. The arbitrator also terms it as an order.
Volume 11.
Volume 11.
Hey, Gopal, dena.
Well, the statute specifically provides that section 16.2 and 3, and the arbitrator also refers to section 16.2. Yes, my lord. The awards, or rather the order, I'm sorry, starts at page 1526.
Yes.
My lord, we'll see. Also, my lord, if the minutes prior to that, 1524, if my lord kindly takes.
Yes.
1524, the minutes of the arbitrator, my lord, paragraph 2, the order of the learned tribunal is as printed with these minutes is pronounced. The order. The arbitrator has never construed this as an award. Thereafter, my lord, 1526, the order starts. There are two applications being disposed of. One is my application under section 16 on the point of limitation. The arbitrator records that he's passing the award, the order, I'm sorry. I have to correct myself there. The order under section 16.2, he refers to judgments of the Honorable Supreme Court to that effect as well. My lord, directly, if I may come to those findings, page 1538, the findings of the tribunal start. Paragraph 11. My lord, we'll see on the point of limitation. 11A, on the point of limitation, as urged by the respondent, this tribunal finds so and so. Thereafter, findings, my lord, on merits, I'll address, my lord, if my lord is entertaining the application. I'm not on that. My lord will directly come to.
No, I'll entertain only if you are able to, if that point is raised, then we'll decide that. If you are
on maintainability, my lord. The merits, my lord, I will have to address after my learned senior friend addresses.
On maintainability, if you are pushing that maintainability issue, then I have to decide that.
Yes, my lord. Yes,
if you're not pushing it, then,
No, my lord, I have to, on instruction, my lord, I'll have to place reliance upon that because, my lord,
show me how it's not maintainable.
Yes,
show me from
yes,
the.
yes, my lord, yes. My lord, will kindly note the application, my lord, arbitrator comes to his findings on the point of limitation. And thereafter, my lord, will kindly see page 1542. Here, the judgments of the Honorable Supreme Court are relied upon on section 16 specifically. So the arbitrator is aware and conscious that this is an order being passed under section 16.2 and 3. My lord, 1542, subparagraph G. With regard to the jurisdictional basis of the learned tribunal, section 16 of the 19, my lord has that?
Yes.
Yes, 1996 Act. This tribunal usefully relies upon the discussion in paragraph 7.13 and 7.14 of Uttarakhand Pur Sainik Kalyan Nigam Limited versus Northern Coalfields, reported at so and so. May I place the quoted portion by the of this judgment in view of the provisions of section 16 and the legislative policy to restrict judicial intervention at the pre-reference stage? The issue of limitation would require to be decided by the arbitrator, including any objections with respect to the existence of validity of the arbitration agreement. Section 16 is an inclusive provision which would comprehend all preliminary issues touching upon the jurisdiction of the tribunal. The issue of limitation is a jurisdictional basis which would be required to be decided by the arbitrator under section 16 and not the High Court at a pre-reference so and so. So I'm relying upon this to say that section 16 order on limitation is a point of jurisdiction that's squarely covered under section 16.2 and 3. Thereafter, Mulal will kindly see the rest of the discussion is there. The arbitrator relies upon this, and then finally the finding of the arbitrator at page 1545. If Mulal kindly takes. Indian farmers is also referred
quoted.
to.
Indian
yes,
farmer is there.
Is quoted. Indian farmers is also quoted. So, that's at page 1543. I can place that as well. Paragraph 16 may I place of Indian farmers as quoted by the learned arbitrator. However, Shri Sinha has argued before us that the award dated so and so being a ruling on the arbitral tribunal's jurisdiction would fall within section 16 of the Act, and inasmuch as the decision taken on the point of limitation was rejected and the drill of section 16 must be followed, in which case all other issues have to be decided first, and it is only after such issue are decided that that such an award can be challenged. So it contemplates rejection of a section 16 under section 34 of the act. Section 16 lays down what in arbitration law is stated to be competence principle, that an arbitral tribunal may rule on its own jurisdiction. At one time, the law was that the arbitrator, being a creature of contract, could not rule on the existence of the validity of the arbitration clause contained in the contract. This, however, gave way to the principle of competence. Well, I'm skipping over that. Well, paragraph 20 Muller also discusses jurisdiction. These sections make it clear that competence principle, which is also followed by the English Arbitration Act 1996, is that jurisdiction mentioned in section 16 has reference to three things. One, as to whether the existence of a valid arbitration agreement. Two, whether the arbitral tribunal is properly constituted. Three, matters submitted to the arbitration should be in accordance with the arbitration agreement. That jurisdiction is a coat of many colors, and that the said word displays a certain color depending on the context in which it is mentioned is well settled. In the classic sense of official trustee, jurisdiction, I'm skipping over that. So, here in Indian farmers as well, subject to correction by my learned senior friend, there also the issue was a rejection of a section 16 application, and thereafter, that not having the colors of an interim award being challenged thereafter. Will kindly see the finding of the arbitrator at 1545. In view of the aforesaid discussion, the tribunal finds that it is competent to rule on limitation. In view of that discussion on jurisdiction, the arbitrator holds limitation applicable to claims 2 to 9 supra and holds that the claims are barred by law. Claim number 1 survives for final adjudication in this proceeding. Now, we'll kindly take section 16, 2 and 3 ones of the Arbitration Act. May I place reliance on the statute itself? I'll place reliance only on section 16, 2 and 3 and thereafter section 37 and just one decision of the Honorable Division Bench ruling on this.
There were two aspects on which the tribunal has decided. One is the point of limitation as far as the claims are concerned. So one claim he said it's permissible, the others he has rejected on the grounds of limitation. And the second is
on the issue of recalling my witness.
Additional evidence.
That he has decided in my
Additional
favor.
evidence.
Yes. That we haven't challenged either.
It doesn't look like an interim.
Yes. But I'll address your lordship. Let my learned friend finish.
Well, section 16, 2 and 3, Muller has seen
just a
16, 2 and 3, Muller.
Yes.
A plea, section 16, 2, Muller. A plea that the arbitral tribunal does not have jurisdiction shall be raised not later than the submission of the statement of defense. However, a party shall not be precluded from raising such a plea merely because he has appointed or participated in the appointment, not our case, Muller. 3. A plea that the arbitral tribunal is exceeding the scope of its authority shall be raised as soon as the matter alleged to be beyond scope of its authority is raised during the arbitral proceeding. And thereafter, Muller, subsection 5 and 6, Muller, perhaps will be relied upon by the petitioner. Muller, 5, may I please? The arbitral tribunal shall decide on a plea referred to in subsection 2 or 3, and where the arbitral tribunal takes a decision rejecting the plea, continue with the arbitral proceeding and make an arbitral award. So it contemplates rejection of a section 16 plea. And 6, Muller, a party aggrieved by such an arbitral award may make an application for setting aside such an arbitral award in accordance with section 34. Now, Muller will kindly see this. All of these 5 and 6 contemplate rejection of a plea under section 16. Now, directly, Muller, section 37, I'll place. I won't take much time, Muller. 37 of the Act, Muller. 37(2), subsection 2. An appeal shall lie to a court from an order. Muller will kindly know the use of the word order of the arbitral tribunal, A, accepting the plea referred to in subsections 2 and 3 of section 16. So my humble submission is, as per this, if a plea under section 2 and 3, 16, 2 and 3, which the arbitrator himself is deciding as referred to in the order itself, is accepted, which has been done in the present case, an appeal is the appropriate remedy. The petitioner is not without remedy. Well, it has to be an appeal. It cannot be a section 34 application. That's my first submission. Well, just one judgment I'll rely upon. Well, may I hand over? It's an unreported decision. Well, neutral. Lord, here, in this division bench judgment.
Here also, The learned Advocate General was there.
Yes. Well, I'm sure my learned senior friend is aware of it. I'm just placing reliance upon two paragraphs. Nothing much, my lord. My lord will kindly come to there. No paragraph numbers. My lord will kindly directly come to the internal page number 6, my lord. My lord, the page numbers, my lord, will find on the top right. P5, P6, my lord, top right it's there. APO so and so, P1, P2. Page 6, my lord, will kindly directly come to. Muller will kindly see the second unnumbered paragraph. There is no ambiguity in our mind by virtue of inclusive definition of an arbitral award that the interim award is regarded as an arbitral award and capable of being challenged under section 34. However, section 16 of the 1996 Act bestowed powers upon the tribunal to adjudicate upon its jurisdiction. Subsection 2 of section 16 of the Act of 1996 provides a right to raise a jurisdictional issue before the arbitral tribunal itself, and such jurisdictional issue can be decided by the tribunal itself and jurisdictional issue arbitral tribunal itself under subsection 1 of the said section. Section 37 of the Act of 1996 provide a remedy by way of an appeal against an order of the tribunal accepting a plea referred to in subsections 2 and 3 of the of section 16. The question thus being begging an answer whether upholding jurisdiction upon repelling, it should be repelling, the contention of the appellant in this regard can be regarded as an interim order or merely an order under section 16.2 or 16.3 of the 1996 Act. What logically follows from the combined reading of section 16 and 37 of the 1996 Act is that in the event the jurisdictional issue raised by the parties to the arbitral proceeding is accepted, such order is capable of being challenged by way of an appeal under section 37, categoric finding. On the other hand, converse does not appear to be the same. Sections, while incorporating section 16 of the Act of 1996, the legislature was conscious that an order rejecting the contention on the jurisdictional issue is not an appealable order under section 37 of the said Act, which can very well be perceived from the provisions of contained under subsection 5 of section 16 of the Act of 1996. The said subsection postulates that in the event the arbitral tribunal takes a decision rejecting the jurisdictional plea, shall continue with the arbitral proceeding and make an arbitral award. It is thus manifest from the aforesaid provisions that the rejection of a jurisdictional issue, unless it strikes at the root of the jurisdiction, is not an arbitral award, far to speak, and of interim award. Otherwise, it would frustrate the legislative intent by incorporating the expression continue with the arbitral proceeding so and so. The scuttle to section 16 on the misconceived proposition that the rejection of the jurisdictional issue would still be regarded as an interim award is unacceptable. That judgment also deals with a case where a section 16 was rejected and repelled. There, the division bench again upholds the order of the learned single judge that a rejection of a section 16 is not an interim award. Today, my submission, single bench, a similar view has been taken by a coordinate bench. I'm not placing reliance. The division bench judgment is there. I'm not going to multiply judgments. My humble submission very simply is, the arbitrator contemplated the application filed by my, and Malad can kindly note, I can refer to the page number as well, 1469. I'm sorry.
Yes.
I'll just sum up on the point of maintainability only. Number one, the arbitrator consciously passed an order as recorded in the minutes. Arbitrator passed an order specifically relying upon judgments under section 16.2 and 3. and also taking note that limitation is a jurisdictional issue contemplated under section 16(2) and 3. That order, my lord, also disposed of another application, which is a purely procedural application for recall of the claimant's witness. This does not satisfy the tests of an interim award, number one. Number two, if the legislature has incorporated subsection 2 to section 37, that an appeal would lie against an order accepting a plea under section 16(2) and 3, my lord, what is mandated by law has to be followed. A procedure that has been stipulated has to be followed in toto. They have a right of challenge. Undoubtedly, they have a right of challenge to this order. This is not the correct form, and this is not the correct jurisdiction which has been invoked by the appellant or petitioner before, my lord. So, my lord, I humbly beseech, my lord, to dismiss the application on the point of maintainability as a section 34 application. Let them take whatever recourse they have against the order. They are not left remediless. That is the sum and substance of my submission, my lord. My lord.
Yes. My lord, limitation is a mixed question of law and fact. Limitation is not a point of jurisdiction of a tribunal or any adjudicating authority. Limitation is an issue as regards the maintainability of the claims or the subject matter. It has got nothing to do with the jurisdiction of the adjudicating authority. Therefore, my lord, section 16, my lord, in my respectful submission, would not contemplate, my lord, an issue of limitation. An issue of limitation is, my lord, something alien to, my lord, jurisdiction of the adjudicating body. Now, kindly have a look to, my lord, section 16.
Interesting. Yes.
The arbitral tribunal may rule on its own jurisdiction, including ruling on any objection with regard to the existence or validity of the arbitration agreement. And for that purpose, an arbitration clause which forms part of a contract shall be treated as an agreement independent of the other terms of the contract, and a decision by the arbitral tribunal that the contract is null and void shall not entail ipso jure the invalidity of the arbitration clause. Then, my lord, the procedural aspect. আচ্ছা আমাদের ইউটিপি সেকশন 16 টা পেজ নাম্বার কত 147 My lord, may kindly take note my objection to their section 16 application, which your lordship would find at page 1479. Volume 1.
Volume 10.
10th volume.
Yes.
My lord, if your lordship may kindly take me to internal page 3.
Yes.
4A. The said petition has been filed on the ground raising objections with regard to the with respect to limitation, issue questioning the conduct of so-and-so and issue of authorization so-and-so. I state that the same are beyond the scope of the petition of section 16. But there were three aspects where I highlight, my lord, the limitation aspect. But this was, my lord, point urged that limitation has got nothing to do with section 16. Then, my lord, the delay, etc., but I don't, my lord, trouble your lordship with those. Now, my lord, the Arbitration Act defines an arbitral award to include an interim award. But on the point of limitation, whether it is an interim award or not, my lord, the Indian Farmers Association case is there. But may I place the relevant paragraphs, my lord, on this issue from Indian Farmers? My lord, we are sorry, my lord, we don't have a hard copy, my lord. Kindly excuse us, my lord.
We'll provide the hard copy.
There's a soft copy for your lordship, my lord. Please take the first paragraph of the judgment.
Then, you know,
Oh,
I can
it's
make
not gone.
I can make a request to you.
I'm sorry.
We should now make our courts digital.
Yes.
We need your support.
Right.
Delhi, Ranchi,
Yes.
everywhere is. We need your support. We need your.
One more thing, Milord, kindly do not take me amiss. Milord, the honorable judges should also, Milord, be adapt, Milord, these
At least
practices.
the ones who are ready to do it.
Yes.
There are quite a few of us.
Yes.
We are ready to do it. We need more support from the
I
state.
think, Milord, when Justice Bindal was here for some time, Milord, I had interacted with his lordship, Milord, to introduce
Right.
this, but thereafter, Milord, things have
We should again initiate.
very well.
We'll have a chat on this.
Very.
Yes.
Paragraph number 1. An interesting question arises as to whether an award delivered by an arbitrator which decides the issue of limitation can be said to be an interim award, and whether such interim award can be set aside under section 34 of the Act. But this is the question frame.
ultimately set aside hold করলো 23/7 যেটা বললো on 23/7 thought it was
Milord, the arbitral tribunal, Milord, on 23rd of July, Milord, decided the issue of limitation, which is, Milord, in paragraph 2. But I don't trouble your lordship with that. Then, Milord, Mr. K.K. Venugopal's submission at paragraph 3, the first sentence at paragraph 3. Appearing on behalf of the appellant, Mr. K.K. Venugopal, learned Attorney General, has argued before us that the award made on so-and-so is an interim award under the Act and would therefore be amenable to challenge under section 34 of the Act as such. He referred to various provisions, etc. Then, Milord, we can skip over and come to, Milord, paragraph number 6.
airdrop আমার আইপ্যাড ওনার কাছে আছে লিখে রাখ মেনটেন প্রাইভেসি আচ্ছা দাঁড়া airdrop অন কর
There are 15.
Yes, Milord. 15, 16, 30. But my learned friend echoes the submissions of Mr. Sinha at para 16 of the judgment.
Maintainable according to this judgment.
May I try to distinguish the judges?
The only aspect of 16.2 and
Yes.
16.3 will go through the rigors of 16.5.
May I try to distinguish the
Well,
judgment? Yeah.
one line submission but on the division bench judgment that my learned friend has placed. But in the division bench judgment, my lord, in that matter, my lord, the question was as to whether the MSME Act at all applies in a case of a works contract. That was the issue. The council held that no, we have jurisdiction. And before the High Court, both before the division bench as well as before the single bench, the point was whether it is an interim award or not. Their lordships were pleased to observe that or come to the conclusion that no, it is not an interim award. And parameters are a bit different.
So far as that.
But that was a jurisdiction of the tribunal.
Which was under.
Yes, which was taken into consideration. And here, Miller, it's not a jurisdiction. It is a question of maintainability of the clips.
How far as 34-37 concerned in this judgment? May I try to distinguish the judgment? Will you kindly take Indian farmers? Will you kindly directly come to only one paragraph?
Can we have it on Monday, sir? Get me a hard copy.
Well,
I have seen it.
if it's possible, my lord, Tuesday or Wednesday. If it's possible, Monday, I'm not.
Only one thing, my lord, Mr. Mukherjee should advise his officers not to object to an adjournment before the tribunal.
My lord,
Because
here
last time
I
it was
cannot-
adjourned on their ground, but
I don't believe a date is fixed, sir.
no, unfortunately, my lord, they have sent an email which ought
that
not
there's
to have
no-
been done,
My lord, today
saying that we did not pray for any adjournment, therefore fix a date.
That's
Well,
not.
That should
only
not be
only
done.
one.
I don't think-
submission. I don't believe a date is fixed before in the coming week. My lord, I cannot. I'm a PSU entity, my lord. I cannot make any undertaking before, my lord, without specific instruction. My client wants to proceed with the arbitration and finish it off because I'm the respondent in the arbitration. My lord, will kindly consider here the appeal section 34, whatever it might be, my lord. If it is decided in Mr. Dotto's favor, my lord, then we will go back to the arbiter. There is no difficulty. There is no reason for the arbitral proceeding to be stayed. Claim 1 is alive. So there's no reason today.
But my claim 2 to 9 has been declared to be barred by
There's no sitting
limitation.
fix. My lord, will kindly not pass any order today. My lord, let
I'm
us
not
complete.
passing any order. We'll keep
But
it on.
let this understanding be there.
Monday, Tuesday.
Let that understanding be there. He's
Yes,
absolutely right.
Sir, Monday.
That are you.
I copy that.
Tuesday.
Could it be on অসুবিধা আছে?
Tuesday.
Monday আমরা দুজন নেই স্যার।
When Tuesday?
Tuesday or Wednesday?
Whenever it's convenient. for both.
Wednesday would be preferable. No, Wednesday. Wednesday. Welcome.
At the request of the party that this matter be listed for hearing on
এই
Wednesday.
ফিক্স করবি কোনো ডেট এই
That
টাইম
this matter be listed on Wednesday.
Fix করে দেন।
Oblige. my lord, I'm also. I'll just indicate.
টাইমের জন্য বলছি।
ঠিক আছে। My lord, I'm just indicating, my lord, in my opening submissions, I had shown the quoted portion of Uttarakhand Pur Sainik. My lord, quoted by the arbiter. I'm formally relying upon that as well. I'm just putting them on notice. my lord.
ये
You already relied on that.
পরের দিন
Yes,
আমি ওটা
ওটা আমি পুরো judgment টা দিচ্ছি।
টাইমের জন্য বলবেন টাইমের জন্য
কটায় লাগে দুটো বলবো
এই যে,
দুটো বলুন
এই দুটো বলবো
I don't have any problem, sir. Whatever
Could it be at 2 o'clock subject to the business of the court permitting?
we have some part. क्या है? कुछ नहीं. We can have it.
I'm grateful.
Oblige.
এই এটা নিয়ে নে
At 2 o'clock. Huh? At 2.
That item number 9 and 10.
Yes, sir.
No, if your lordship will permit me
Mr.
to.
Banerjee, what happened? You have not come to court.
Not today, my lord. The
Okay.
tom yum that I had yesterday did more than just fill my stomach. So, not in the best
The
of
9
health.
is an after notice matter affidavit in opposition.
Lordship, I'm being led by Mr. Banerjee.
Mr. Banerjee, affidavit in opposition.
No, my
But
lord,
may I have a suggestion in
we
this?
had indicated on the last day,
Mr.
9
Banerjee,
and
Mr.
10.
Banerjee,
If Mr. Banerjee
Mr. Lyrie has a suggestion.
has now an award has been partially challenged by us. It was fully challenged by them, but now they are coming up with an amendment for a partial setting aside.
Yes, yes. Well, that's what I had indicated on the last day. With
If the
Mr. Lahiri
entire
will
award
just
is
give
set
me a
aside,
minute.
Just a minute. Mr. Lyrie is making some submissions.
if
Yes.
the entire award is set aside and a new arbiter is appointed, I think
So that's exactly why, my lord, I knew the submission would come. We made a mistake by challenging the entire award. I had submitted on the last day, and your lordship has also been pleased to record that we were to file an application because part of the award is in my favor. Well, none of us are daft to challenge the entire award. We've taken out the application. The application is seeking an amendment only to challenge the limited part of the award by which certain claims have not been granted to me. That's the only scope of the application. Well, if your lordship looks at the application that we filed,
There's the application. Yes.
no
sir.
application, which then we have to file an opposition to the application.
I don't
Look,
have any
opposite-
application. Application again
GACOM 1.
in item 9. Huh? In
Item
Item
10.
9.
in item 10.
In item 10.
Item 10.
Item 10.
9 is there 34 seeking to assail the entire award because they got nothing and the award is in my favor.
In 9, the affidavit in opposition, Mr. Banerjee, I filed it.
No, my lord. I had indicated on the last day. First order your lordship had passed. The next order your lordship will see. My lord has been pleased to record that we are not filing an affidavit because the entire papers that were part of the records of the learned tribunal have been disclosed by me in item number 10. So there's nothing else that the parties really need to or intend to rely on. I think Miss Anamika Pandey had appeared on the last day. She had also
Yes,
made
yes,
the
yes,
same.
yes.
All right. Yeah. Yes. I've recorded. You don't want
Yes,
to file.
yes, Mulad. Because 34 pleadings, anyways, it's going to be on just on the law. Whatever was there before the
He has filed an
tribunal.
application for amendment, which is
Yes,
B1.
Mulad.
We want to oppose then. If they're not in the
Look, opposition, the application is only to the limited extent that the amendment that I'm going to challenge partial.
They
In
can
fact, my 34 is also
limit it
cast on the.
partially. Where's the bar? There's no bar.
Well, that bar, even if he wants to urge.
That's all. I understand that you you are saying that they had initially challenged the entire amount. Now they have become wiser. They want to only challenge certain portion, or probably this is what is affecting them.
Yes.
So they have moved this application seeking amendment of the petition.
Yes.
So this can be allowed.
Well, we want to file an opposition to this.
For this, Mr. Lai?
Changing the nature and character of the entire.
No, Milord. I could
my
have convinced
36
him
is
better if I
pending.
was there next to him.
My 36 is pending. Now,
That's with regard to his 34, Milord. He has his 36.
So
is
my
with regard
suggestion was if two parts of the award is challenged by two parties, let the entire award be set aside and appoint a new arbitrator.
Are you challenging two different parts? No.
Yes, yes.
Yes, part of the award. Milord,
the
part of
which
the
I am
award is in
aggrieved
my favor. So far as forfeiture of security deposit and
So
the
if they want to
illegal
go ahead, I
termination.
have got a case on merits.
So that's exactly Mr. Lahiri always does. So in this affidavit, he can't have an objection. Lord, I am seeking to restrict my scope of challenge.
The submission be recorded and then be order of the court.
No,
Yes,
you want to file a reply. I'll allow you to file a reply.
Kindly. Well, there is a department.
Item 10. Item 9. No need to pass any order. Item 10. Item 9 simply likh dena to be tagged along with item 10. Okay? So to be listed along with APCOM 205/2025. Item 10 mein karo, learned counsel for the petitioner has filed an application seeking amendment of the
Section 34 application.
34 seeking amendment of APCOM 205/2025.
Please.
Section 34 petition, APCOM so. Learned counsel for the respondent seeks and is granted 4 weeks, 2 weeks.
4 weeks takes out after vacation, so
4 weeks time to file his reply to the application, affidavit in opposition. Reply 3 weeks, reply if any 1 week after 4 weeks.
takes us into vacation.
3 weeks, 1 week.
1 week after vacation would be safe, Madam.
So it will go after 1 week only.
Yes.
I'm saying 3 weeks.
3 weeks is inside the
4
vacation.
weeks. 4 weeks. All at 4 weeks. 4 weeks, reply if any within 2 weeks thereafter, list after 8 weeks.
Kindly then tag the 36 along with this.
There's a 36 also.
Yes. This got delisted because they didn't appear.
Learned counsel for the parties submit that APCOM 89/2025 shall be listed along with the present petitions. Let APCOM 89/2025 be listed along with the petitions.
Grateful.
8 weeks after.
Grateful.
Monthly list of February then.
This is February.
Monthly, let it be listed monthly list of February.
Grateful.
I'll come back in 2 minutes.
This is an ex parte interim order, section 34 from an ex parte interim award.
Yeah.
Well, the final award is expected tomorrow. Very well. We shall wait. Because the issue would be when the signed copy was made over to us. The point was that the signed copy was issued on the respondent. It had come back with the endorsement that no such person resides. Subsequently, after writing 2 letters, the arbitrator had handed over the signed copy to the advocate for the respondent. Upon receiving that, the respondent in the arbitration, upon receiving that, within the period of time, we have filed the 34. But we did not have a signed copy. That is an admitted position, and it will be reflected from the minutes as well. And we had written letters requesting for it as well.
But only one thing I should indicate, this stand which is being taken by the petitioner is perhaps a dishonest stand. And why I say so is even till today, any communications made to the address referred to in the agreement between the parties, the postal articles returns with the endorsement were not found. It's their duty to have that changed. Now, as per Section 3 of the Arbitration Conciliation Act, wherever the address is mentioned in the agreement, communications to that address is good service. So, the arbitrator, it's an admitted position, the arbitrator had served the signed copy, that had come back with an endorsement, left, not found, whatever, not found.
So you file your reply.
On this point, Vishal.
If you are
that will expedite things.
And in fact, it was sent by email also. They say
you are saying that you received it on 14th of January.
No, my lord, I have received it in the month of October, and there within 90 days I have filed from the time I received the signed hard copy. In June and August, I have written letters to the arbitrator. The arbitrator thereafter provided me with the copy, and I have filed it within 90 days from receipt of the copy. I was handed over the hard copy.
And they have not even changed the address of the
issue is,
respondent
my
in the
lord,
cost title.
The cost title
So
was
they
prepared
appear
by
in the
them.
proceedings. They don't change that. And they take a defense that it was not served on me, whereas the arbitrator had sent the article which came back with the address. Not. So they should have changed it. We have also tried to serve them. Other applications also in them. Everything comes back.
It was ex parte against me. It was a moving ex parte against me at that point of time. Subsequently, I entered the arbitral
ground to reject it.
But my lord, the address, whether that is the present address.
Kindly directs my affidavit only to the short point of the limitation. I'll give all the documents and assist your lordship on this short point. Because
petition,
on other points, I don't think I need to use any affidavit.
The petition, the petitioner in the present petition. The petitioner by way of the present petition is challenging the interim award. Dated?
It is 13th February 2024.
13th February 2024, passed by the arbitral tribunal. In the arbitration dispute between the parties. Learned counsel for the petitioner states at the outset, learned counsel for the respondent states that the present petition is barred by limitation. Full stop. He states that the petition has been filed beyond the statutory period as well as beyond 120 days. Full stop. The said contention is refuted by the learned counsel for the petitioner, who states that he had received the award on
signed copy of the award at the 21st arbitral minutes
sitting.
He had received the signed copy of the award on, give the date.
My lord, it was on 14th of January 2025.
14th of January 2025. And hence the present petition is filed with a delay of 16 days. That's what he says. Full stop. Learned counsel for the respondent disputes the said position and seeks and is granted 4 weeks, 2 weeks, how much time?
2 weeks.
2 weeks time to file affidavit in opposition, reply to the same if any within 1 week thereafter, list after 4 weeks.
I'll restrict my affidavit only to the limitation issue.
Yes.
Because on the other, really no affidavit is required in a 34.
Lordship, I'm appearing for the respondent in this matter. Lordship, on the last occasion, Mr. Sinha had appeared and given a suggestion that if they would have settled on the outstanding principal amount, they would pay it off. Then, Lordship,
Lordship, I discussed it with my client, Lordship, that on the last occasion also I submitted that, Lordship, there is an order passed under Section 17 of the Arbitration Act by the arbitrator, Lordship, which attached my all bank account, Lordship. That is the embargo, Lordship, as Lordship also pleased to observe that, Lordship, that will not be set aside until the award is set aside. Lordship, in this situation, Lordship, my client is not in a position to, Lordship, settle the matter, Lordship.
Lordship, then to cut short the matter, on merits, I have nothing to say. The award can be set aside and an arbitrator can be appointed here and now by consent of the parties.
All right.
Lordship, so far that appointment of arbitrator, Lordship, that is
That will be set aside.
award may be set aside, Lordship, yes.
Obviously, we have to appoint a new arbitrator.
And
That's what she's saying.
That is what.
Yes, award may be set aside, Lordship,
What
but
she's saying.
appointment is, Lordship, that whether the issue is
If the,
arbitrable.
if the consent,
Consent of the parties, we can. You will not give a consent for appointment of arbitrator.
Lordship, that is there, Lordship, because that
What do you mean?
regarding the agreement also, Lordship,
The
that
award will be set aside. No appointment will be done.
should that because the whether the issue is arbitrable, whether there is an arbitration,
That you can.
so that issue may
That
be
goes before. Every issue is open before the arbitrator. We are only setting it aside. We are not passing any order.
I'm grateful, Lordship.
Take down. This is an application filed by the petitioner challenging the ex parte arbitral award dated 25/1/2025. Received on 3/2/2025, passed by the arbitral tribunal in the dispute between the parties on the ground that the respondent appointed the arbitrator unilaterally without the consent of the petitioner. Full stop. The petitioner challenged the said unilateral appointment before the arbitral tribunal, however, the arbitral tribunal ignored the said application and passed the impugn award. Full stop. Upon perusal of the impugn award as well as the underlying agreement executed between the parties, it is evident that the learned sole arbitrator was appointed on the strength of unilateral arbitration clause in the said agreement. Full stop. The unilateral nature of the appointment, which is that judgment? The unilateral appointment process goes to the root of the arbitral proceedings and raises a foundational issue of lack of authority of the arbitral tribunal. Full stop. In this context, the Honorable Court give the citation, please. Do you have?
Yes, sir.
CORA, right? Central Organization for Railway Electrification. Just give the citation. Has categorically held that an arbitration clause which confers exclusive authority upon one party to unilaterally appoint the sole arbitrator gives rise to a justifiable doubt as to the independence and impartiality of the arbitrator, and such clauses are in violation of Article 14 of the Constitution. Applying the aforesaid settled legal position to the facts of the present case, this court is of the considered opinion that the appointment of the learned sole arbitrator, having been made unilaterally by one party, stands vitiated in law. Full stop. Consequently, the ex parte award dated 25/1/2025 cannot be sustained and is liable to be set aside. full stop. Accordingly, the impugned award dated 25/1/2025 passed by the learned sole arbitrator is hereby set aside, full stop. At this stage, learned counsel for the parties submit that they are agreeable to the appointment of, give a name,
Should be anybody from the High Court panel. There's a panel.
The claim as on date is around 29 lakhs, Lordship.
will appoint some lawyer or
Anybody of choice of your
will
lordship.
appoint a lawyer.
Lordship. Yes, sir.
Shabir Ahmed,
Yes, Lordship.
appointment of Mr. Shabir Ahmed as the sole arbitrator to adjudicate the disputes and differences arising between, full stop. In view of the consensus arrived at, the matter is accordingly referred to the said learned sole arbitrator for adjudication, full stop. The learned sole arbitrator shall be at liberty to determine his remuneration and shall conduct the arbitral proceedings in accordance with law, full stop. The parties are directed to forthwith communicate a copy of this order to the learned sole arbitrator, full stop. It is clarified that this court has not entered into the merits of the claim or counterclaim of either party, full stop. All issues are left open for consideration before the duly constituted arbitral tribunal.
Lordship, I have given the citation.
With the above direction, the present petition is disposed of.
Lordship, that item number 13 is my 36(2), Lordship, application under section
12 and 13.
that may be disposed of, Lordship. Another
What is this?
36(2), Lordship, my application for the stay, Lordship, that may be also disposed of, Lordship. And another, Lordship, my execution is also running in the monthly stifle, Lordship, please to dispose of that also.
36. Since
269 item.
Since the arbitral award has been set aside, the present application has become infructuous. The same is dismissed as infructuous. 36(2). And what is that?
269 of the monthly list, Lordship. That is the execution of the arbitration. That
we'll keep it on Monday.
I'm grateful, Lordship.
Execution, you keep it on Monday. Give that date. You withdraw that execution application.
That is not filed by me, Lordship. That is filed by the.
You withdraw that application.
I am not appearing in the execution, Lordship.
Who's appearing in
There is another advocate on record who
Can you
appears.
inform that person?
Yes, I'll do that.
It's in monthly list, Lordship. So if you appear in the daily list, then they will follow. I'm grateful. 269 of the monthly.
Execution Thursday डाल देना ना. Thursday ऊपर डाल देना.
Grateful, Lordship.
Or I just take that the other matters. The contempt matters. कितना है 15 10
Appellate side, item number 1.
I am appealing on behalf of the petitioner. I filed these contempt applications against the violations of your lordship's order on dated 22nd April 2025. I have
Which
already
municipality is
communicated
this?
the order.
Show me
I
the
think
order.
the relevant portions of the order, page 18. It has specific direction upon the alleged contemptor. Next, relevant portions, page 19. To take steps to dispose of the complaint lodged by the petitioner within specific time. But till date, they have not taken any steps against the unauthorized construction. They are not interested to comply with the order passed by your lordships. Without any sanction plan,
Which municipality is this?
actually,
Paniati.
Panihati Municipality, Chairman Park.
The petitioner has preferred the present contempt application alleging willful disobedience on part of the respondent the municipality in failing to comply with the order passed by this court on
22nd April
22nd
2025.
April 2025 in WPA number 879 of 2025. Full stop. Respondent shall file an affidavit of compliance within a period of 4 weeks. Let the matter be listed on. Give a date. Hey, Gopal, उस दिन बाकी मैटर हमने 8 को दिया था 8 इसको 8 को नहीं देके इसको फिर हम देते हैं कब का करते हैं 15 है ना 15 कर देते हैं 15 January.
Yes, I'm grateful to you.
Next.
Item number 2.
Lord, I'm for the petition. This is my application.
Yes.
Hearing already concluded, my lord. Order is ready to serve the parties, my lord. Kindly 3 days time given.
The
order is appearing at page 20.
16-7 order, right? Order of 16-7.
Yes.
All right. The petitioner has preferred the present contempt petition, alleging willful disobedience of disobedience on part of the respondent municipality in failing to comply with the order passed by this court on 16/7/2025 in WPA number 20947 of 2024. Full stop. Learned counsel for the respondent municipality seeks and is granted 2 weeks time to file compliance affidavit. Let this matter be listed on the 15th of January.
Yes, my lord. Deeply. Copy services.
Item number 3.
Three. None for the petitioner. In the interest of justice, adverse orders are deferred. List on, or maybe dismiss or default. The file or restoration. Next.
Item number 4.
For your lordship, I am for the petitioner. Lordship, non-compliance of the order dated 20th of May, your lordship, 2025.
Yes, Mr. Banerjee.
A copy may be given to me. This is the first time.
Yes.
My lord,
Hand over a copy.
Lordship, I will serve your lordship.
someone junior actually appeared in the matter that I can see, but I appeared now. Let it be regularized, my lord.
All right, एक line लिख लेना. Same violation of order dated 20th/5/2025 in WPA number 23706 of 2024. एक line लिख देना. Learned counsel. हाँ, learned counsel for the respondent, Mr. Sandeepan Banerjee, who appears for the respondent municipality, is present in the court. He has been asked to assist in the present matter. Let his appointment be regularized. Learned counsel seeks and is granted. 2 weeks, 3 weeks?
4 weeks, my lord, I will.
4 weeks time. 3 weeks time to file his compliance
My lord.
affidavit. List on 15th of January.
15th of January. Let a copy be served to me, my lord.
Lordship, I will serve your lordship.
Item number 5.
My lord, 5, 6, and 7, my lord, I am appearing for the petitioner, my lord.
Yes.
All the matter, my lord, common judgment passed by your lordships on different dates.
Pension?
Yes, my lord. My lord, that judgment delivered on 15th of July, my lord. Kindly turn to paragraph 18, my lord.
Yeah, I can see that.
Order was communicated, but till date, my lord, non-compliance of your lordship's order.
इसमें कर देना disobedience of order dated. What is the date of the order?
15th July 2025.
15th July 2025 in WPA number 18494 of 2024. 18494 of 2024. Respondents are directed to file their compliance affidavit within a period of 4 weeks. List on 15 January.
I'm grateful to you. Next also same 15 July order dated.
Dated 15 July in WP number?
W?
Petition number W.
WPA number 964.
964.
Of 2024. 2025.
2025.
25. देखिए देखो ना पार्वती जाओ
चेक कर दो भाई
ठीक चलो हाँ 7 my lord order dated 30th June
30th June.
30th June.
WPA number?
WPA number 963 of 2025. Okay.
Item number 8.
Lordship, item number 8, Lordship, before opening the brief, I would submit, Lordship. The municipality diligently tried to contact the petitioner, but there is no number, and problem is that we could not find out the spot. And the municipality tried to contact with the learned advocate for the petitioner to provide the mobile number to the petitioner. Since petitioner was not residing there, we could not identify the spot. And the learned advocate for the petitioner did not cooperate. Then they informed me. I personally request the learned advocate for the petitioner to provide the phone mobile number of your petitioner, since they are not residing there. The municipality
all of it is verbal, my lord. Nothing is in written.
Now do it.
It has to be
Lordship,
substantial.
kindly allow 3 weeks time. The municipality complied with direction to the petitioner to cooperate to identify the spot.
My lord, it was the same admission by the respondents, my lord.
So
In
that
the, my lord has
municipal
recorded in page
engineer
number 21, my lord.
detect the original spot.
Sir, whatever you have to do, you do it. Comply with the order.
Lordship.
Only concerned with the compliance of the order.
Lordship, only that.
Order dated 9/7/2025, WPA number 30573. Learned counsel for the respondent seeks and is granted 4 weeks time to file compliance affidavit. Let this matter be listed on the 15th.
I have not been served the copy.
Give a copy.
I'll give you
Lordship, my lordship, only indulgence. Lordship, kindly direct the petitioner to identify the spot.
Sir, I'm in contempt.
Lordship,
do whatever steps you have to take.
Otherwise, Lordship, we are tried by our level best to identify the spot, Lord, but
Spot
I
is
did
in-
not.
My lord has recorded the spot in paragraph number 1.
Paragraph number 1.
Carried out in
This
jail
dark
number
number,
44,
Lordship, we are not
30 and
able
number
to,
648.
unable to identify the
Dark number
Write a letter to him.
Lordship.
Have you written a letter?
Nothing, my lord.
Lordship,
Where's the letter? Show me the letter.
Lordship,
Show me the letter you have written.
I have personally called him.
Where is the? I'm not concerned. Where is the letter which you have written? We
Lordship,
don't believe
I
in
have not,
personal
Lordship,
communications.
Lordship, we shall communicate, comply
You
the
are
order.
appearing for an authority.
Lordship,
You
we
don't
shall
call.
comply.
You write.
Lordship, Lordship. I'm grateful, Lordship.
Sir, আপনার কাছে copy of this number টা
একটু দিন নামটা লিখে দিই নামটা আচ্ছা
Give a copy.
Item number 9.
Immediately, my lord.
Item number 9, my lord, I am appearing on behalf of the alleged
Yes.
contender, my lord. Kindly direct the petitioner to supply the copy of the contempt. And we
Why
have
are you
given the notice to the hearing was conducted, my lord. The next date of hearing is fixed on 24th December, my lord, in presence of both the parties, my lord.
Where is he? Nobody's here. Where's the order?
Order dated
8/7, right?
Your lordship directed us to consider his representation on the basis of, as per directions of your
You
lordship.
considered the representative.
We have given a hearing, my lord. They have present, and subsequently another date of hearing was fixed on 24th December 2025, my
Then?
lord. 24th December is
24 December.
yes, my lord. The
Will
first hearing was conducted on 3rd December
You were supposed to
2025.
finish it within a
Yes,
time
my lord. There is a delay, my lord. In our part, my lord, I am praying unconditional apology for that, my lord. And the 16th was fixed for inspection of the premises, my lord.
The petitioner has preferred the present petition. None appears for the petitioner. The petitioner has preferred the present petition seeking. वही कर देना. Order dated 8/7/2025 in WPA number 27098. Learned counsel for the respondent seeks and is granted 4 weeks time to file compliance affidavit. List on.
Only direct them to supply the copy of
There's nobody.
because no copy of the serve apnas.
Think about contempt. What?
I'm
You know what is the contempt?
I'm grateful.
Item number 10.
जो dismissal default भी जो है ना मत करो. Yes.
I am for the contempt of merit. I have to take instructions regarding the, but the petitioner is not appearing. In any manner, I will come with the compliance on 15 merit. But a copy maybe no one is there also. But still, no copy, I will even comply the order. No problem.
15/7/2025.
I want the lordship's order should be complied.
WPA 9186 of 2025. Your appointment has to be regularized.
Right.
So, पहले order है ना? Mr. Banerjee appears. Compliance affidavit within 4 weeks. List on 50.
Right. Apni petition?
No.
Yes.
No, my lord, it is not this matter, my lord.
Which matter?
Item number 3, my lord. I am for petition first time, my lord, for service of notice, my lord. Contempt matter, my lord.
I'm not dismissing it.
Yes, my lord. I beg your apology. In case of
No problem. I am not dismissing it.
In the meantime, I serve, my lord. Contempt notice be served, my contempt petition be served.
Item 3 ले लो. Take item 3.
But I need not any service now. I can comply without service,
yes.
but still a order may be passed for service. If they see, then they will give me. In any manner, I will have, but they should service. As a contempt should be complied with after being serviced.
Item. What is that order?
I will come to page 33. Operative part, my lord, page 34.
Order dated 2/4/2025.
Yes, my lord.
This non-compliance of order dated 2/4/2025 in WPA number 357 of 2024. The respondents are directed to file their compliance affidavit within a period of 4 weeks. List.
Was it aware?
Oh, you are appearing, Mr. Banerjee. In this also you can appear. South Dum Dum.
No.
No. You don't appear for Dum Dum.
I know one person who appears. I can assist him.
Mr. Bihani.
No, not Bihani. Bihani also appears. Noyan also appears.
All right.
Deep level. Deep left.
Well, item number 10, returnable on 10th.
15th.
15th.
All 15th.
I will comply. I come with
All on.